All right, Jason, go ahead and pop us into the presentation of what you prepared for us here today, and let's go ahead and kick it off.
Sounds good. Thanks, Scott. All right, so I'm going to share my screen with you all. A little bit about myself. I've been a real estate attorney for about a decade. I've been an investor for about that amount of time. And I'm a client as well as an attorney for Royal Legal Solutions. So we're just going to go through this slideshow. So land trust, the first line of defense, kind of as Scott had insinuated, they're not meant to be standalone. They do provide anonymity on their own, but that's about as far as they go, hence the tagline. Okay, so what is land trust? I think it's probably most useful to discuss this in reference to other trusts. So what we have here, we have three different types of trust: revocable, irrevocable, statutory. There are obviously ranges within that and different names within that, which does lead to some confusion, but these are the major categories. So revocable, land trusts are in this category, also known as common law trusts, which means that they're derived from custom or judicial precedent as opposed to code authority. So basically, as the name suggests, they can be revoked, they can be altered, changed. You can update beneficiaries, remove assets, modify it. It gives a lot of flexibility. One of the downsides is there's really no asset protection aside from the anonymity that they provide, but some of the benefits are listed here. You can bypass probate court if it's structured the right way. You get privacy, again, if it's structured the right way. And you can plan for your heirs, again, if it's structured the right way. Obviously, careful planning is key with any of these trusts. The way that you set it up does matter quite a bit. So irrevocable. So as opposed to revocable, as the name states, it can't be changed. You lose a lot of flexibility. There are some huge advantages to it, but basically it doesn't give you any room, not really at least, for change. So it's fixed, it's locked in place. A lot of times these are used to try to avoid or contain the damage that estate tax, inheritance tax would cost, either at the state level or the federal level. Obviously, at the federal level, it's very high right now, so it's not used for a lot of clients. But so that's why it says tax deductions. It is a separate standalone entity, which means you don't control it anymore, which means it does protect you from creditors. And these two are linked with Medicare planning as well. It can shield some of the costs from that. Now, statutory, one of the products that Royal offers and that we use quite a bit, but there are other statutory trusts in other states. But the one we focus on for our purposes is a Delaware statutory trust. And as it states here, rather than being based on common law or custom or judicial precedent, it's based on statutory law or code. So it's updated regularly, especially in Delaware. It's one of the most business-friendly states. It's updated by business law experts on a very regular basis. They're relatively simple to form. As I suggested, they are regulated by statute, so it's internally regulated, not done by the client themselves, as far as the rules and everything that are set in place. And it does have creditor and bankruptcy protection. And it is a really great product to be using with a land trust when it backs up to a land trust, just like an LLC could back up to a land trust. And we'll get into that more in detail later. So common myths to dispel about land trusts. So as you can read, I'll just go through each of them. So land trusts don't make you anonymous. Well, that's true if you are the trustee on it, if you're the beneficiary, if you're the grantor, and you have it all kind of out there, if you decide to record it for whatever reason at the county level, or if you have to file it, that's true. But if you use a nominee trustee, which ideally would be an attorney, or possibly you could use a third party, you can get some anonymity, at least at the county record level. They can find you in the chain of title. So as I said, I was a real estate attorney for about 10 years before I was with Royal. I'm still a real estate attorney. I did a lot of title work. While that's true, they can find you in the title. You're just going to be a prior record title holder. What I care about if I'm looking through the chain of title is who the current record title holder is. Doesn't really matter that your name is on a mortgage if you had financing and you transferred to the trust, because unreleased mortgages are extremely common. They could be out there for a lot of different reasons. They're not going to find you as an owner currently, which is kind of the key point. Land trusts provide lawsuit protection. Again, as I said, not really. They'll provide you anonymity, which in a way provides you lawsuit protection, but that's just kind of stopping things before they even get started. But once they get started, as Scott said, it really wouldn't do much unless it's backed up by an LLC or a DST. Mortgages prevent you from using a land trust. Again, not true. The Garn St. Germain Act does specify several exceptions to due on sale clause violations, one of which is being if you transfer from yourself to a revocable trust where you are the trustee and you are the beneficiary. And the key here is you still are the beneficiary technically if you have a wholly owned LLC. There's an exception there. Honestly, this doesn't come up that often. Mortgage companies, generally speaking, as long as the note is paid, they're not going to bother you about it. It does happen occasionally, but you have a really solid argument when it does come up, if it comes up. But again, 99% of the time, it never even shows up because mortgage companies aren't checking the record. Land trusts are limited to holding raw land. Again, false. I mean, they can be used to hold raw land, but they're good at holding a wide variety of properties, whether it's developed, undeveloped, notes, syndications. You can do a lot of different things with it. Although the name land trust kind of insinuates that it has to be limited to land, that's not really the case. So top benefits, as I said, you can own an investment anonymously to a degree. You can avoid the due on sale clause, as I said. You can obtain financing in the land trust, or it's very easy to move out of the land trust and move back in, get financing while it's in your own name, then move it back in. But people do actually finance in a land trust as well. Hold any type of asset in all 50 states, not just land, as I said, and then stop lawsuits before they start. Like I said, if it looks like you don't own it, generally speaking, you're not a good target. So that's where that tagline comes. So do you need a land trust? Well, it kind of depends, obviously, like most things in life. We'll get into that about 2 slides advanced. So the bigger picture, as I said, land trusts are just one part of the structure. Obviously, you could just do a land trust, and there are applications where that may make sense. But generally speaking, at Royal, we kind of focus on all 5 of these pillars here. So land trusts really are going to focus on anonymity. That's where they're going to come into play. The liability, separation, and isolation, that's going to come when you pair a land trust with an individual LLC per property or per asset. You're going to get that liability, separation, isolation, so that if someone breaks into the land trust, they're going to have to get through an LLC. Worst case scenario, you have compartmentalized everything. They get into that one LLC. And then the 5th pillar is obviously insurance, which that's standalone, but we would always recommend that, you have homeowners insurance. An umbrella policy would be good as well. And then you could have general liability insurance for an LLC. A lot of people don't know that, but it's a little bit duplicative, but sometimes it does make sense to have that. So who needs a land trust? So if you have a single family home, really how it works is with the Garn-St. Germain Act, anything from 1 to 4 dwelling units is within the realm of single family. So if you have a single family home investment property, it may make sense for you to have a land trust structure with backed up by DST or LLC. Syndications also make sense, notes as well. And are you interested in owning things anonymously, then also a land trust would be a good option for you. If you don't have any of those things, then this conversation is probably just informational. So again, as we've been talking about, and I said in a couple slides before this, the focal point of a land trust is really going to give you the anonymity, because instead of having your LLC, which I can look up and figure out who the manager, who the membership is, find your registered agent, probably within less than 5 minutes, I could figure all that information out. With the land trust, it's normally a private agreement, something that you would keep in your house or place of business. So no one has access to it unless you're taking screenshots or sharing it all over the place. So the anonymity part is where the land trust comes in. And as it suggests, it's good for a wide range of investments, and it doesn't disrupt financing, generally speaking. So for hard assets and soft assets, generally you can use it the same way. What you're going to do is you're going to use the land trust at the property level. So whatever the county is, it's going to be transferred from, let's just say, John Smith to 123 Main Street Land Trust. Generally speaking, you have to list the trustee in most states. Actually, every state that I'm aware of requires for a valid conveyance, the trustee has to be named. Otherwise, it's not really a valid conveyance. You avoid the due on sale clause, as I suggested earlier. You can finance properties in your own name and then move them. And then any disclosures, really, as we were kind of discussing in the question and answer section, any disclosures to insurance companies or banks, your CPA, that's really all confidential. It's not public domain. It's not really searchable. That's not the kind of anonymity that we're really talking about. We're talking about somebody who's looking for trouble and hasn't yet filed a lawsuit, hasn't gotten into discovery or anything like that. Just they're kind of sizing you up. And if they can't size you up, again, you're not a good bet most of the time. Most of what we're defending against are contingency attorneys, which I don't know how familiar you guys are all with it, but generally you catch what you kill. I was a contingency attorney for about a year. We took 30 to 40% of the winnings, but if there are no winnings, or if it doesn't look like there's going to be winnings, we wouldn't fund it. So generally speaking, that's who you're trying to dissuade from suing. So soft assets, they pretty much follow the same routine as hard assets, which are, houses, cars, things that generate liability. Things that don't generate liability, examples would be syndicates, technically speaking, notes, things that brokerage accounts, things of that nature. Generally speaking, you can use the land trust with them, or you could actually put them into an LLC directly in the same structure that the larger structure that we're talking about above. But obviously, land trust is a good option if you don't want anybody to know what you own. And it would be the same thing with a nominee trustee out front. That's what everyone would see. And then a generic trust name. So beyond the land trust. So this is talking about the larger structure. We'll get into some diagrams here. But when the land trust is paired with an LLC or a Delaware statutory trust, that's when you really get the liability separation, isolation. So what it's going to look like, generally speaking, in the trust that Royal Legal creates, you have three parties. You have a grantor, beneficiary, and trustee. What it's going to look like is, instead of you being the grantor or the founder of it, instead of you being the beneficiary of it, we're going to make an independent LLC, or possibly a series LLC, or a series of a Delaware statutory trust. We're going to make that the beneficiary and the grantor. So once the land trust, if obviously it's hypothetical, if the land trust gets broken into, then they have to contend with an independent LLC or an independent Delaware statutory trust. So that's what gives you the limited liability. The land trust on its own, if it's just you as beneficiary, grantor, and trustee, it's just going to collapse on itself under pressure. Generally speaking, that's what happens. So adding an LLC or a Delaware statutory trust to the mix is where the magic really happens. And again, as I insinuated earlier, or discussed earlier, the attorney-client privilege at the bottom end. So with the land trust, if you have the nominee trustee being Scott or another attorney, that's going to delay or stop discovery requests pretty much outright, just because you have attorney-client privilege. It's a privilege held by you as the client, unless you give him permission. Scott or the attorney couldn't really discuss much in the way of who the trustee is, who the beneficiary is, who that grantor is. So the LLC and everything in the background really wouldn't even be disclosed. So anonymous entities. So this is a version of a land trust that we do. It's not called a land trust. We call it an agent trust. But basically, at the bottom end, you have at the county record level, if I'm looking in the county, I'm going to see Scott Smith as trustee of the 123 Main Street Land Trust. Okay, that's great. If I'm looking at another level, which is the Secretary of State page, if for some reason I have a tip-off about an LLC that possibly backs up that property, you also have anonymity at that level. So Texas, wherever, there's only a handful of states that don't allow this, and it's a very small handful. So what we would use to give you anonymity at that level, at the Secretary of State level, is, generally speaking, you'd have a manager. So John Smith would be the manager of Smith LLC. Well, what we do at Royal is we create a very simple trust. Again, it's private, just like the land trust. So it's going to be held in your house or place of business. It's going to be a trust between you and yourself, and that will become the manager of your LLC. So now when I go to the Secretary of State site, instead of being able to see John Smith as manager of the Smith LLC, I will see Smith Agent Trust as manager of Smith LLC. So it creates, you're tying up the county level and you're also tying up the Secretary of State level, and it kind of creates anonymity on both ends, which just makes it really difficult and frustrating for someone to try to figure out who owns it. Okay, so this is a snippet of the entire structure. Obviously, there's more, and we'll get to that in the subsequent slides. But basically, this is what it would look like. As you can see, you have the property, and it would be owned by an independent land trust. Usually, the name takes the address. So like I said, 123 Main Street Land Trust. Scott Smith would be the trustee or nominee trustee initially. Upon recording of the deed to this property, Scott would drop out, and it would become you as the successor. The beneficiary and grantor of this land trust, privately in that land trust agreement, would be an LLC, whether it's a child series of a series LLC or a spoke like this, an independent LLC. And then this LLC would be owned by a hub LLC or a parent LLC. And then, as I was discussing in that previous slide, that LLC would be owned and controlled by an agent trust, which would be owned and controlled by you. And so this is the much larger picture. So we just looked at this right here. But in the background, you also have all of this. And this is like a complete schematic. Obviously, no one has to have all of this, but this is the full comprehensive plan. So as we discussed, this all goes up to a hub. Agent trust owns and controls the parent LLC. And then generally speaking, if you have an estate plan in place, you would have a living trust be the beneficiary of this agent trust. And this living trust ties into an estate plan. So that way you could plan for your beneficiaries, your heirs to get everything. It would all flow up to it as the pinnacle. It's a really nice way of avoiding probate, which is a public, lengthy, and sometimes expensive process. And then what we always recommend, or nearly always, is if you're dealing with hard assets, especially, you should have an operating side. So at Royal, we try to separate the liability of holding something or owning something is enough in and of itself. We try to separate the interaction side into an operating company, just because that generates a good deal of liability. So what you have here is, it mimics pretty similarly this parent. You would have an agent trust here that owns a traditional LLC. So again, I can't figure out who actually manages it because it's managed by a trust. And so this would do all of your interactions, and that could be hard assets or soft assets, really. So on notes, it could be a servicer of notes. On hard assets, it could hire contractors. It could enter into leases. It could evict tenants. It could, if you have a third-party rental manager, just interact with them. And that way, all those contracts, all those interactions are all on this side, not on this side. You keep this out of that realm entirely. I don't want to use the word decoy, but it is a first line of defense. It's usually an empty shell that just collects and then sends everything to you or to the parent on the holding side. So generally speaking, if this gets sued, it's not a complete loss. It's a shell, as I said. The owner's manual, how to use land trusts. So again, this is just going to give you kind of a breakdown of what it looks like when you buy, refinance, sell. So buying a property, generally speaking, people can buy directly in the land trust, and some people who prefer to not have the name of record at all or very little, they'll do that. It's a more expensive process just because it would require an attorney to sign your closing documents, which that comes at a cost. So generally speaking, the easiest way to do it, the way that I've done it myself as a client of Royal, you acquire the property in your personal name. You usually get the best financing that way. After closing, via warranty deed, you transfer it to the land trust. And then selling property. Same idea. Some clients do have success selling directly out of the land trust. Now, some title companies are going to make you jump through some hoops, and it is not always the easiest thing. So generally, the recommended way of doing this would be, once you decide to sell your property, you have it up for sale and everything, the easiest thing to do is to just sell it, or just transfer it back to your own name, enter under contract in your own name, sell it. At that point, you're talking about, closing at this point is 4 to 6 weeks. You're talking about 4 to 6 weeks where it's sitting in your own name. So generally speaking, not a huge liability there. That's the easiest way to do it, most straightforward. A title company is not going to bother you at all. Refinancing kind of follows the same pattern as what we just talked about. Generally speaking, you're going to want to, you have it in the land trust, move it out of the land trust, into your name, refinance, move it back to the land trust. Now, this is going to be subject to the financier's seasoning period. Sometimes it's before, sometimes during, sometimes after. It just kind of depends on what they require. But as noted, there can be up to 6 months seasoning before you can move it back and forth. And then frequently asked questions. So taxes. For the land trust, it's a pass-through entity. It's disregarded. Generally speaking, it's always going to come back to your personal return. LLC or a corporation that owns the land trust, or it could be a DST, as I mentioned. Generally speaking, the way that we create them at Royal, the default is usually it's just, a sole proprietorship or husband and wife ownership. And if that's the case, all income is just going to be back on your personal return. Now, that can change a bit if you elect S Corp status, C Corp status for your LLC. Do I use insurance with the land trust? Yes. So you would add the land trust as an additional insured onto each policy for each property. You would keep yourself intact, and it would just be an additional insured. Generally speaking, from my experience, this does not cost any extra money. And then as far as cost, so generally speaking, 550 is kind of the number that we're looking at here. And that is in isolation. Obviously, you're going to want probably a bigger structure because just moving something into a land trust doesn't make sense, as I kind of said. But 550 to move something from your name into a land trust, create the land trust, create a warranty deed. Usually, like I said, it's done in tandem with creating LLCs or DSTs. And then as well, to use an attorney as a nominee trustee would be $500 per year. And that is unlimited. As many properties as you have, you would be able to use one of the attorney's names at the firm. And that would give you that attorney-client privilege.